Good day, everyone. It is really a great honor to be here today, and thanks to God first, and thanks to our kind organizers, we got the chance to meet each other in person finally, and to establish those connections that should exist between our countries, and especially between the scholars that are working on the issues of religious freedom. I have prepared the article, the paper for within the Central European Professors Network that deals with so-called multi-tiered registration systems that are operating in a number of European countries, and especially in our countries. My presentations will be very close to the presentation of Professor Šanda. I swear to God that we had no communication before this event, so this is just happened that we have prepared something that is very close, topics that are very close. Let's try if, oh, it works. This is what Professor Šanda already explained. That is the so-called multi-tiered registration system. You can see that there is a top tier, let's say, or highest tier. And in this tier, there are religious organizations that enjoy the most favored treatment. Ordinarily, they have access to, you can see their tax benefits, state funding, they enjoy tax exceptions, etc. There is a second tier, usually or intermediate category. Religious organizations have recognized legal personality and the ability to obtain some privileges, but not to the same extent as the religious organizations that belong to the highest tier. And finally, there is the lowest tier that provides usually basic legal personality, but with no possibility to of acquiring any state-provided privileges or benefits. Usually, religious organizations are free to choose in which tier they want to belong, but the requirements for registration in higher tiers are extremely difficult to attain. So most of small and newly established religious organizations cannot fulfill them. This model also includes states that distinguish traditional churches and religious communities, like Republic of Serbia. Those systems do not violate the international standards of protection of religious freedom, but a European Court of Human Rights has found violations of the European Convention in almost every case that involves such systems. My paper focuses on Serbian legislation in this field, so reasons for introducing different categories of religious organizations in Serbia can be understood only if we go one step back to the socialist legislation on churches and religious communities. As Professor Šanda says, there is always history, and also here we should speak about history. The 1953 law on the legal status of religious communities does not prescribe any obligatory registration of religious organizations. Although their legal personality under civil law has been recognized. The 1977 law on legal status of religious communities was valid only, I'm talking about the law that was valid only on the territory of the Republic of Serbia, There were other similar laws in other states of Yugoslavia, and they are all similar, except the Croatian one. This law had stipulated the duty of citizens who establish a religious organization to report the establishment of a religious community to the municipal body in the charge of internal affairs, to the police station, in other words. There were no special requirements that religious communities had to meet in order to submit the application, nor were there any procedures which needed to be carried out by state bodies. Everything changed in 1993. The law on the repeal of certain laws and other regulations actually changed this law on the legal status of religious communities, and in the period between 1993 and 2006, there were no regulations governing the registration of and the legal status of churches and religious communities. Their legal personality was recognized, although it was not regulated by any law, bylaw, or any regulation. Newly established organizations could opt to register and to acquire the status of legal entity in accordance with the regulations on citizens associations. The law on churches and religious communities, which was passed in 2006, regulates the legal position of religious organizations, and the Serbian legislator has implemented one of the variations of the multi-tier systems by dividing all religious organizations into three closed categories, stratified categories. Traditional churches and religious communities, confessional communities, and other religious organizations. That's exactly what the law says. Those are not my words. Churches and religious communities that have the most favorable legal treatment belong to the category, of course, of traditional churches. This category includes churches and two religious communities that meet two conditions. The first is that they have centuries-old historical continuity, and the second is that they have acquired legal personality in the past on the basis of special laws. There is a whole range of relevant evidence about the centuries-old historical continuity of traditional churches and religious communities, including regulations concerning their activities. Their legal status was regulated by special laws in the period before the World War II, before 1941. These are 5 churches and 2 religious communities that are listed under the law on churches and religious communities, together with legal acts on the basis of which they have acquired their legal personality in the past. So the distinction between the traditional and other religious organizations is based on objective criteria which do not allow the state bodies to arbitrarily decide on the acquisition of the most favorable status provided by the legal system. The mentioned criteria derive from one general legal principle, namely, during the communist rule, traditional churches and religious communities were illegally deprived of numerous rights, and they have acquired on the basis of previous laws. Just as there was an obligation for the legislator to regulate the restitution of unlawfully confiscated property following after the Second World War, there is also an obligation to regulate the restitution of rights and privileges that have been unlawfully taken away from religious organizations. So the recognition of their legal personality ex lege represents a kind of restitutio in integrum. This, when the law on churches and religious community came into force, there were also religious organizations that have acquired legal personality on the basis of liberal Yugoslav regulations. By law, these religious organizations have been named confessional communities. Their legal personality is not recognized ex lege, However, the legislator had envisaged that they must be registered under the new rules, under the new conditions. A particularly sensitive issue arising from such a legal solution is the issue of continuity of their legal personality. Should that continuity be interrupted, there is a possibility that the confessional churches and communities could lose their acquired rights. This issue had been resolved by the rules on the content and manner of the register of churches and religious communities, which stipulates that the date of first application submitted by a religious community shall be entered into both the register and the decision on the registration. So confessional communities actually will be recognized since the date of their first application according to Yugoslav regulations. Since confessional communities as well as traditional churches and religious communities possess the same legal personality at the time of the adoption of the new law, it can be argued that due to different legal treatment, confessional communities have been subjected to discrimination. In accordance with the Constitution of the Republic of Serbia, all churches and religious communities are equal, of course. Equality of religious organizations does not mean that they are all same and identical, but it comprehends adequate exercise of rights guaranteed by legislation. Equal treatment in legal practice and doctrine is not identical treatment, but a more sophisticated treatment in accordance to the specificities of the issue at stake. This attitude is best expressed by Pliny's legal proverb, Nihil est tam inaequale quam Aequitas ipsa. Nothing is so unequal like equality itself. Or to put it in the words of Gerhard Roberts, to safeguard the religious liberty, the correct paradigm is equal rights, not identical rights. Equality among religions, therefore, means adequate use of all the rights in an equal way. From the perspective of equality, differences are possible as long as they are legitimate. They have to be based on legitimate reasons. And there are some objective circumstances arising from the system of registration applied in former Yugoslavia, which have imposed a different legal treatment on confessional communities. Namely, the Yugoslav legislation lacked any notion concerning the central register of religious communities. The intention to introduce a central register was the main reason for constituting a special category of confessional communities. The existence of a central register implies that the entry into it is conducted under certain conditions, only in the situation when certain facts which are entered into the register are known to the competent authority. As authorities throughout the former Yugoslavia, as regards to the confessional communities, they have applied before local police authorities throughout the former Yugoslavia, while no central registry was kept in regard to their applications. The state authorities of the Republic of Serbia do not have insight nor records of these applications. In fact, state bodies are not able to determine and check which religious organizations actually belong to confessional communities. In order to register them under the register of churches and religious communities, it is necessary for them to submit the data about them which state does not possess. In contrast, the data on traditional churches and religious communities are available to state authorities, and this is the main difference between the confessional and traditional churches and religious communities, which is the basis for a different registration procedure for them. Just to conclude, My paper deals with one variation of multi-tiered systems, and it would be desirable in the future to focus our efforts to analyze those systems and to identify the positive practices that emerge from these systems, because that will help us to improve those systems of registration, and also that will help us to defend them if it becomes necessary. And it will be necessary in the future, because this system of registration is closely connected to the model of church-state relations. Professor Shanda already said that cooperation model, something between cooperation and accommodation, probably in the United States. The state cannot cooperate with all religious organizations on the same way. It's impossible. So those systems of registration helps us, and the cooperation system is not only optimal. I feel and I think that it's necessary for our countries because of the decades of persecution of religion in our recent past. In the end, I would like to thank you all, and I will be grateful to hear your insights and questions during the discussion. Thank you so much.